May it please the court, good morning, Your Honors. My name is David Jaffa, and I represent Mr. Horne. I also know him as Ernest Brim, and that's how the pleadings are styled. Mr. Brim has been in prison for a long time, and I concede that the issue I am arguing this morning is extremely narrow. When Mr. Horne first asked me to look at his case, I took considerable time to look through 7 volumes of the record that's here. I believe it's one of the last cases that's not digitized. And I went to the Arapahoe County District Court, and I spent some time looking through it because I had the same questions that are raised by the people in trying to figure out what Mr. Horne's claim was. So when I came across, buried deep in the file, that which he labeled Exhibit N in the hearing before the Arapahoe County District Judge, and that was part of the record in March of 2015, wherein Judge Jones, then trial Judge Jones, had found that a particular conviction in which Mr. Horne had entered a plea was not voluntary, was not knowing. And in the minute order attached to that Exhibit N, it reads, defendant's motion to suppress alleged conviction of April 1486. It's written as 04-1486. I'm not quoting directly. Granted, conviction of 04-1486 is suppressed and stricken. What should have happened, I suppose, right after that, Mr. Turner, who's a well-known lawyer, might have suggested to Mr. Horne might have done something to actually suppress that conviction other than simply suppressing it for purposes of the hearing that was before Judge Jones. Now, and I overlooked that a little bit. The purpose of Mr. Turner's motion was to suppress it for habitual criminal purposes in that particular case. Having had a district court find that the plea of an underlying conviction was unconstitutional, it would have been proper, I believe, in looking back on it, to then file a separate 35C at that time and get that conviction vacated. That did not happen. And in Mr. Horne's mind, for the next 30-some years, he understood that that conviction was unconstitutional. And he was correct, except for some problems along the way, not the least of which, and that's probably the elephant in the room, is on a separate appeal, when that particular conviction came before this court, Judge Jones, then sitting on this court, the same trial Judge Jones who had ruled before, found that that conviction that he had originally found was unconstitutional was now perfectly fine. And there was no reason not to consider it for other purposes along the way. Those facts get buried in reams of paper over the next 30-some years. And that is why, and this is not part of the record, so forgive me because no one knows what I did, but it took me hours to get through those documents to actually find this one point. And Mr. Horne filed numerous documents. In 1994, as the record shows, he filed his first Rule 35C in what he claims is his only Rule 35C. I direct the court to the colloquy between Judge Washoppel and Mr. Horne in March of 2015. And there, in that record, which I thank the people for bringing to the court's attention, because even though I had originally endorsed the record, it didn't get up here. But in their brief, the people noticed it wasn't here, so we supplemented. But at pages 131 to 132 of that transcript, the court will find a colloquy between the district judge hearing the Rule 35C finally in 2015 and Mr. Horne, who says, I thought that conviction was gone. I honestly believed I did not have that conviction on my record. Now, I concede, he was wrong. And Mr. Horne had problems with his lawyers all the way along. The record is clear on that. I concede that point. And having worked with Mr. Horne these last few years, I can appreciate certain frustrations that lawyers might have had, but that is not our problem, I don't believe. We have this narrow point of a conviction having been found to be unconstitutional for purposes of habitual criminal. It wasn't found by preponderance of the evidence that maybe we shouldn't hear it in an habitual criminal hearing. It wasn't found by some standard lower than a constitutional standard, because the standard for suppressing a conviction at an habitual criminal hearing is the same as any constitutional violation, and it's very exacting. The statute is clear on that, and our case law is clear on that, that if I bring to a district court a motion to suppress a prior conviction for either impeachment purposes or for habitual criminal purposes, I'm held to the same standard as I would be for a 35C. That is, I have to show that it was unconstitutional on its face. Judge Jones made that finding. Procedurally, for the next 35 years almost, my math may be off a little, and I apologize, but from 1987 until 2015, because that conviction was not actually vacated, it was held against Mr. Brim.
Counsel,
Go ahead.
I'm sorry, can you frame for me maybe a little more precisely exactly how and when was counsel ineffective? Because that's the essence of your claim.
Correct, and in wanting to remand it for that hearing. In April of 1987, so between April of 1987 and April of 1990, another 3-year period, looking back on the case, I would have, and this is dangerous territory, I admit, and especially with Mr. Turner, because I have the greatest respect for him, I would have filed a separate Rule 35C on that lower court conviction to get it vacated, because that's what never happened. Yet we have factual findings and legal findings that that conviction was unconstitutional. But in his argument, and I realize I'm jumping around, but I'm trying to just keep a stream, and that is this. In 2015, when the prosecutor argued before Judge Washoffel that, look, you know, that conviction still stands. It was never vacated. Even if it was found for purpose of habitual criminal to be unconstitutional, no one ever vacated it along the way. It was ineffective assistance of counsel to not file a motion or not advise Mr. Horne that that's what has to happen for that conviction to go away. He could not rely, as a legal matter, he couldn't rely for the next 30-some years because trial Judge Jones found it was unconstitutional. As a technical procedural matter, he wasn't able to rely on that technically. I am saying that counsel should have advised him, or quite frankly, the court should have advised him. So not is it only perhaps ineffective assistance of counsel as a legal matter, but it may very well be something that he should have just been advised of, not unlike a Rule 11 advisement where a court is obligated to make certain advisements in addition to what counsel might advise a client. So the failure to actually vacate that is what I find to be the problem. Now, I'm having thought through this, I'm fairly well aware of the argument back. Well, he didn't do it, so didn't he waive it? So that's his problem. He has to live with that now. But when we're talking about a constitutional, had it been anything other than a constitutional standard, we may not be here today. But when it comes to a case, to a plea that is unconstitutional, while the technical knots have not been tied, it's still unconstitutional. It's still wrong. It's still not fair to use that against him. How can something be unconstitutional on one day and perfectly fine on another day?
Mr.
And that's
Jeff,
never been resolved.
Mr. Jeff, in that regard, let me ask you a question. You seem to suggest in your briefs that there was some improper conduct by former Judge Raymond Jones in ruling first that and granting a motion to suppress when he was a district court judge and then denying a motion to suppress on the very same conviction as a Court of Appeals judge. Are you suggesting or stating that he did anything improperly?
Well, Judge Taubman, if I might, first of all, I've appeared in front of Judge Jones a few times, both as a trial judge and here, and I'm not suggesting he did anything unethical. So when the court uses the word misconduct, I want to make clear, I believe, yes, as a legal matter, it was certainly inconsistent and something that should raise an eyebrow, the same as if, you know, if when Judge Davidson was a trial judge, had she come here as a Court of Appeals and then heard that same case as a Court of Appeals judge, it may be perfectly fine according to our rules. There's no rule I'm aware of. I cannot cite any law that says that, but it would seem to me, to the public, it would seem, how can a judge who tried a case also then decide if any rulings made in that case were proper? It just, so I'm not, I certainly want to be clear, I'm not saying Judge Jones himself did anything unethical or bad in that sense, but there's an appearance of impropriety on its face there. But beyond that, I think it is appropriate to have a hearing on, okay, some years after he decided one way, he decided another way. How does that happen? How can something be unconstitutional based on standards in 1987 and then become constitutional 8 years later in 2005 before this court, when it's not been appealed? Now, again, I want to make that point, which is this. The people didn't appeal this ruling. It's not like this ruling was before this court. It was an ancillary matter. The people didn't appeal the ruling of Judge Jones, the trial judge, and say, no, that we should be able to use that conviction for purpose of which. That's not what happened. That would be different. This was ancillary. This was, well, he brings it up now as part of a separate case. But, so the standards remain the same. It wasn't like that this panel, a panel of this court, was reviewing whether Judge Jones, the trial judge, properly or improperly determined constitutionality, which this court could do if it had been brought before the court in a proper manner, but which it was not. It was not appealed. So that's what I'm saying is the difficulty. So with that, if I'd like to reserve the balance of my time to rebut.
Very well, Mr. Jaffa. Thank you.
Thank you.
May it please the court, my name is Lisa Michaels, registration number 38949, and I represent the people of the state of Colorado. There are 4 reasons that the defendant's appeal fails. First, there's a jurisdictional defect. Second, his 35C motion is time barred. Third, his claim is successive. And fourth, it fails on the merits. Now I'll talk about each one, starting with the jurisdictional defect. This case should be dismissed for lack of jurisdiction because the defendant failed to file a timely notice of appeal. He filed it 76 days after his motion was denied, and he hasn't shown good cause for to excuse the untimeliness. He has provided no explanation for why he could not file it within the 49 days required by the rule.
So, Ms. Michaels, forgive me for interrupting you, but isn't it the case that a motions division of our court allowed the appeal to go forward?
You're correct, Judge, and but this division is not bound by the motions division, especially because we're talking about a jurisdictional issue, and that can be raised at any time. So the second reason, if you're not inclined to dismiss it for lack of jurisdiction, the second reason his appeal fails is because his 35C motion was time barred. Now, he did file the motion in 1994, and it was timely at that time, raising the claim, but he abandoned that motion by failing to seek a ruling on it for a total of 11 years. Now, the defendant has mentioned the numerous documents and pleadings that he filed. Now, that's true, but those were in isolated periods of time. The history can be broken into 4 separate periods. Initially, when the 94 motion was filed, that's true, he filed numerous motions, had numerous problems with attorneys, various attorneys were fired. At the end, that concluded with the firing of one of his final attorney in that litigation, and then almost 6.5 years elapsed where he filed no pleadings at all. After that period of time, he then filed the 35A motion raising the same claim. In other words, he changed course, decided to pursue it as a 35A claim. After that was concluded, it went all the way up through appeal. Then there was another 5 years that elapsed where he filed no additional pleadings. At that point, he did file a motion asking to have the 94 motion ruled upon, but it was too late at that point. It was already abandoned. And then the motion he subsequently filed is time barred. Now, in his brief, the defendant...
Counsel, excuse me for not recalling this from the record, but what was the disposition of the 35A that went up on appeal? First of all, did it involve this issue?
It did. This was the identical claim. Now, I didn't have access to the record in reviewing immediately before I came here, but so I can't remember exactly what the district court said. I know that I put in my brief that they reviewed it on the merits, but it may have been something, they may have not reviewed the constitutionality of the plea. I can't recall, and I wasn't able to review that. And then on appeal, this court decided that the motion was time barred because they said it was actually a 35C claim. But they did mention, for purposes of discussing the untimeliness, that he had previously raised it in the direct appeal, if that answers your question.
Yes, it does. Thank you.
So now I was going to say that in the brief, the defendant mentioned the Grist case for the proposition that the judge must rule within a reasonable time on a motion. But the Grist and the cases leading up to it apply to 35B motions, not 35C motions. But assuming that it does apply to a 35C motion, Grist also says that the defendant has an obligation, an affirmative burden, to make reasonable efforts to secure an expeditious ruling on the motion. And it also says that a motion may be deemed abandoned if there is an unreasonable delay in getting it resolved.
Ms. Michaels, I understand your comment that a defendant has an obligation to move a case forward or to request a ruling on the motion, but does the record indicate at all why his original motion was pending for so long without a ruling from the district court?
Well, initially, I can't remember what period of time it occurred after he filed the motion, but it was over a couple of years at least, I think, where he was I think that initial delay was, so I'll just start from the beginning. He went to hearing on it, and the judge who looked at each and went through each of 85 claims and ruled on each one of them. He denied this claim, the claim that we're talking about, whether that prior conviction was invalid. He denied that as successive because it had been addressed on the direct appeal. But then he told the defendant he could supplement the motion by claiming, for example, that counsel was ineffective. And he did later do that. He filed many, many additional motions, and he was having problems with his attorneys, asking to have them withdrawn. And so that was the initial delay. After the final attorney in that period of time was withdrawn, there's no indication of why. My guess, which is all I can offer, is that somehow it just got buried and slipped through the cracks. But it's his obligation then to seek a ruling. I mean, he let 6.5 years pass before he did anything else with regard to the claim. And then he just filed it as a new claim and had that taken up all the way through appeal. But if you're uncomfortable with the idea that he abandoned that motion and you don't want to call it the new motion time barred, you can affirm the district court's ruling that his claim is successive because it was addressed on direct appeal. Now, the defendant is relying heavily on the fact that former Judge Raymond Jones, who authored the opinion in the direct appeal, issued a previous ruling in an unrelated case as a district court judge on the same issue. Now, it's an interesting quirk, but it's ultimately meaningless. Judge Jones was not bound by his prior ruling, and there were 3 judges that decided the appeal in the direct appeal, 3 judges in that division, and both of the other judges concurred with Judge Jones's opinion. Now, another factor that I think is relevant is the judge, sitting as a district court judge, you're making decisions from the bench. Judge Jones made that decision from the bench. As a court of appeals judge, there's briefing, time to reflect, and again, input from 2 other judges. But ultimately, he wasn't bound, either way, he wasn't bound by his prior ruling. And most importantly, for purposes of this discussion, it doesn't, the fact that this additional fact does not transform this claim into a new or different one. We're still talking about the same claim, and it's already been addressed, so it's successive. Now, to the extent that the defendant is claiming that his ineffective assistance of counsel claim regarding the prior conviction has not been addressed, he can't simply recast his claim as one of ineffective assistance of counsel to defeat the successiveness. And the reason for that dovetails with the fourth reason that this appeal fails. That determination on direct appeal that prior conviction was invalid precludes his ineffective assistance of counsel claim. That is, as a matter of law, counsel was not deficient in failing to get that prior conviction suppressed because according to this court, that conviction is valid. So that claim fails as a matter of law, and there's no prejudice for the same reason. Now,
Counsel, this is a little bit ancillary, but the standard of review, obviously, from this court's perspective, is different from what a trial court's perspective. But I would think in the issue in front of us, it was probably de novo either way in determining the constitutionality. If not, was there a difference in the way Judge Jones, as a trial judge, was required to judge the merits of the issue? Was that different from the way the panel reviewed that issue? And if so, would it matter?
I don't think there's a difference, and I don't think it matters, if that answers your questions. So with regard to some comments that counsel made here today about the defendant's attorney, Mr. Turner, that was the attorney, I just want to clarify, that was the attorney in this other unrelated case where Judge Jones, former Judge Jones, as a former district court judge, issued the ruling there. He has no basis for claiming ineffective assistance of counsel Turner in this case. So I just want to point that out. The bottom line here is that the defendant's claim has been addressed multiple times, and he's here looking for yet another bite at the apple or a sympathetic judicial ear, which is not permitted by the rule. If there's no additional questions, I'd ask this court to affirm the district court's ruling.
Thank you, Ms. Michaels.
Thank you, Your Honors. Judge Jones, in his original opinion, in the transcript and in his handwritten notes, as well as the minute order, in the transcript shows a number of elements and reasons why he suppressed the guilty plea of the underlying case. None of those reasons has ever been addressed by this court or any other court. It's always been summarily addressed as it's already been raised, and that's it. In the 17CA case, there was no discussion of the facts underlying the plea. There was no discussion whether it was a good plea. Now, I'll concede that framing a perfect argument here is difficult because so many things have happened. But frankly, something is wrong. When a plea is determined to be unconstitutional and a trial judge lists the reasons, he didn't just say granted. The transcript is clear, and that transcript is before the court. The reasons the plea was unconstitutional was not knowingly made. Those reasons were never addressed by anybody to this day. So to say that Mr. Brim has had his day in court on that point, I don't believe is correct. As far as the jurisdiction of this court, I accepted it as so. People said we didn't address it in the opening brief. It's true because I was unaware that it was an issue. I still don't believe it's an issue for all the reasons that I took time in my reply brief to address it. At no time did Mr. Horne abandon his Rule 35. I can answer Judge Taubman's question directly. Judge Leopold set the matter for a hearing sometime after he went through the listing of all the things he would hear and not hear. Mr. Brim was in jail, was in prison. He was never writted in. The hearing was vacated. He called the court to find out. There is actually a note in the record about that. And they said, well, it was, the hearing was vacated. And that happened a few times. He never abandoned anything. There were two court reasons, and if the court reads the March 2015 transcript, Judge Washoffel said on numerous occasions, this is why I've granted you these continuances. But so to further elucidate the record is why she said it. But that is clear then that Mr. Horne, Mr. Brim continually sought ruling. We believe that the merits of this case are that an injustice has been done here because of the lack of review of the unconstitutional plea. We request reversal. Thank you.
Thank you very much, Mr. Jaffa. Thank you again, Ms. Michaels. We very much appreciate your oral arguments on this case this morning. The case will stand submitted and a written opinion will issue in due course. We're now ready to hear the oral argument in Murway versus Allstate Insurance, so counsel can set up after it. The bailiff we're here for the oral argument in Murway versus Allstate Fire and Casualty Insurance Company. The bailiff has just informed us that plaintiff's counsel George Nichols is not present. I gather you're Gregory Morris, is that correct?
I am, Your Honor.
Do you have any information you can share with us about Mr. Nichols being here or not being here?
I didn't receive any voicemail yesterday. I haven't communicated with him. If you would like me to go check my email in the hallway or something, but I have not heard anything from him. I assume if you called my office, somebody probably would have let me know as well.
I think maybe that would be appropriate if you could check your email and see if you have received any word from him. And let me just ask you now, if you haven't heard from him, do you wish to go forward with the oral argument?
A brief oral argument, Your Honor.
Okay, so why don't you go ahead and see if you can check to see if you have received anything from him, and then come back and let us know, and then we'll go from there.
Thank you, Your Honor.
Thanks. Mr. Nichols' office, and his office has indicated that he is on his way, but he is not here, so we will see if he shows up in the next few minutes, but in his absence, we will go ahead with the argument first on behalf of Allstate, and then we'll see where we go from there. So, Mr. Morris, why don't you introduce yourself? And I know we're in an unusual position because you're not responding to any opening argument, but please go forward.
Good morning, Your Honors. Greg Morris on behalf of Allstate, Colorado Bar Number 49363. I had indicated to the three of you earlier that I would make this brief. Very simple matter as far as I'm concerned. Just the briefest of backgrounds. Plaintiff, underlying case went to trial. Following the jury reaching its verdict, plaintiff's counsel, Ms. Murway, attempted to file an amended complaint and bifurcate that complaint. That was subsequently denied by the trial court. We're here today on Ms. Murway's appeal, wherein she says the judge abused her discretion in denying those two motions. I've reviewed plaintiff's opening brief. I see absolutely no case law supporting his argument that the court abused her discretion by denying these motions that were filed after the jury reached its verdict. What I do see is a lot of arguments that leave should be freely granted. I'm not here to tell you that it should not be, but there are exceptions to those rules. And Ms. Murway, while citing some case law, fails to continue to cite the remainder of that law wherein it does go through some situations wherein a court can deny a motion for leave to amend, one of which is undue delay. I have a hard time finding a more undue delay than waiting until after a jury rendered its verdict. This is the absolute last possible time that this could even be conceivably done. It's undisputed. Plaintiff knew of these allegations that he wanted to add to the amended complaint, the bad faith allegations. It's undisputed per his own brief that they knew these at least 3 weeks before trial.
What about the fact that one of the claims is a statutory claim, and that particular statutory claim revolves around compelling the insured to institute litigation and then ultimately recovers more than, the offer is substantially less than the amount ultimately recovered. That seems to be at least something that couldn't really have been known prior to the jury returning its verdict. I mean, that creates a slight unique twist here on justifying the delay when that statutory claim is being asserted.
I would say yes, except for the fact that it is well documented that he knew of this possibility far in advance. Mr. Nichols, is sending letters before suit was even filed, saying that that the offers from Allstate are outrageous. They're far beyond the scope of what this is necessary. He easily could have averted this entire situation by just filing that with his original complaint.
Does a claim under that subsection accrue prior to the jury's verdict?
Yes, it can, but in that situation, again, like I said, he had knowledge of this, and I think it's within the discretion of the judge not to allow the amendment after the jury reached its verdict. I mean, it's an abuse of discretion standard here, which I think is very, very high. The reasoning for that, like I said, throughout the case law, undue delay is one of the reasons not to grant leave to amend. And I think by knowing about these, alleged issues far in advance of the trial, he unduly delayed and failed to properly or timely amend his complaint.
Counsel, let's say that you're correct about, I'll sort of look at them discreetly. There's common law claims, there are several other statutory claims under Section 10.3, and then there's the claim that Judge Welling just referred to. For the latter, assuming that the statute says it only accrues after a jury verdict, I'm not clear on, from, at least from the briefs, would Mr. Nichols be precluded from then filing a new claim for that particular statutory claim? Not the others, not the common law claims and the other bad faith statutory claims, but this discrete one, if it accrues only after a jury verdict comes in, and then you have knowledge that, oh my goodness, this big disparity.
I think that would be in the discretion of the court on where he files it. I don't believe that was raised in Mr. Nichols' opening brief.
Well, I'm not talking about whether you could amend the, I'm talking about filing a new claim. And I think there was some reference in the briefs perhaps to a claim preclusion issue, which of course didn't really go anywhere, but would there be, I'm just thinking of prejudice, I mean, would he have been, I don't know what the timing is now, but would he have been precluded from filing a new action on that particular statutory claim?
Mr. Nichols, in fact, actually did file a separate action in federal court that has been stayed pending the outcome of this appeal.
With all of his bad faith claims, or just this one?
All of his
I mean,
bad faith
All
claims.
of them, okay, all right.
So let me just follow up on my colleague's questions, Mr. Morris. So if, can you explain your reasoning as to how the plaintiff could have filed a claim before a jury verdict based on the statute that Judge Welling mentioned without knowing in advance how the jury might rule?
Again, what I will stress is what I had said earlier, that he knew, or he had a reason to believe, that this case was worth far in excess of what the policy limits were, and he had received multiple demands, or I'm sorry, I apologize, multiple offers from Allstate years before this, before the verdict was rendered. He had an idea of what this verdict would be, and he chose not to file it. So I believe that he should have known what this potential verdict could be based on his knowledge of his own case.
Let's put it differently. Had 3 weeks before trial, he asserted a standalone claim under 10.3.1104 1H7. Wouldn't you have been able to move to dismiss that at that point? I mean, the claim hadn't accrued. Had the amendment, had that claim been asserted prior to trial, what's the factual basis for it?
I clearly see what your question is. The factual basis for that would be, I guess, I mean, it's hard to argue what the factual basis would be for that. I mean, it is a awkwardly written statute, if I would say so. But I stress that there were other claims that he could have made that he chose not to bring in to this lawsuit. The basis for this suit is whether or not the basis for this appeal is whether or not the trial court judge abused her discretion in denying these two motions to amend. And I think that's what's before this court here today. And I don't believe he has shown anything that demonstrates that the court did in fact abuse its discretion in denying these motions. It relied on well-established case law for delay, for prejudice to the non-moving party. And that, I mean, that's how I would say that. Mr. Nichols does cite in his reply brief a Minnesota state action, which when I did look up doesn't seem to apply to this matter at all. It seems to rely on the fact that per statute in Minnesota, after a jury verdict, they're to amend to seek taxable costs. Obviously, if that's a statute there, it really doesn't have any effect by us. But no, I mean, again, like I said, I believe that what's before this court today is whether or not the trial court abused its discretion in denying the motion, number one, to amend, and number two, to bifurcate. And my argument on the bifurcation is if the court is so inclined as to believe that the trial court judge did not abuse its discretion in denying the motion to amend. Well, I mean, the bifurcation issue is moot because there's nothing there to bifurcate. I just, like I said, I think the argument before the court, and if the shoe was on the other foot, to be honest with you, and we were the moving party here, and the judge had granted the motions, it's just such a high standard to overturn, and I just don't think, without citing any Colorado law specifically on this, how the judge could have abused her discretion if she followed the applicable case law as to when to grant or deny amendments.
Mr. Morris, let me ask you to stop your comments. I see counsel is seated at the appellant's table. Are you Mr. Nichols?
I am, Your Honor, and I apologize. For some way, this got put on my calendar for 11, and I actually thought I was going to be at least an hour.
Well, as you can see, Mr. Nichols, we have started the oral argument that was scheduled for, not for 11, but for 9 o'clock. And by my watch, it's 12 minutes until 10. Mr. Morris has started with his argument and has argued for 10 minutes. So what I'm going to suggest is that, Mr. Morris, that you step down, and that Mr. Nichols, we will give you 10 minutes for your oral argument, and then Mr. Morris, you can conclude with your 5 minutes, and then that's what we will do, and that way we'll be able to adhere to our schedule. Let me just check with my colleagues to make sure that they're in agreement with what I have just suggested. So they have nodded, and they have indicated that what I just said is satisfactory with them. So you will have 10 minutes for your oral argument, and Mr. Morris, you can use your remaining 5 minutes to respond to Mr. Nichols' argument, and that will conclude our oral arguments in this case.
Thank you, Your Honor. For the record, my name is George Nichols, counsel for the appellant in this matter. My attorney registration number is 5862. My position with regard to this case is, when does an individual have the ability to file a bad faith claim under the statute that we've cited, specifically under 103-104 H 6 and 7, where the insurance company, in essence, makes no real offer at you. In December of 2016, we were finally able to get expert reports because my client had lost her primary care doctor and had come to Colorado from Texas and was examined the end of November. We get the reports in the IME just before Christmas. Based upon...
Counsel, if I can interrupt you, because I want to
Yes.
get to the heart of this, since your time is limited. I understand you brought, one of the claims you allegedly were going to bring was the one under 1104. But in your proposed second amended complaint, which I guess was never filed, you argue, or you allege, several other kinds of bad faith claims, under 103-113, under common law, under 115, 116. So, I mean, are you lumping all these together? Or, in my mind, I sort of see them a little bit separately. And what I would like you to address is, how did the court abuse its discretion concerning the claims other than the 1104 claim? And as far as that latter claim, why couldn't you have brought that as a separate claim if it didn't accrue, a separate independent claim, not as an amendment, if it didn't accrue until the jury verdict came in?
Well, I'll answer that last question first. I, in fact, did that very thing when I filed a case on August 22nd of 2017 in the Denver District Court, 17CA1357, not only to assert that claim, but also to preserve the statute of limitations, for fear that if during the pendency of this claim, the court ruled in our favor, but we hadn't, and made the ruling that, well, you needed to file an independent action, to avoid the next argument being, well, it's outside the statute of limitations, because there's been arguments that I think have now just recently been resolved by the Supreme Court.
Okay, so let me clarify. So on that one claim under 1104 1H7, is that the only claim for relief in the new case that you filed?
I believe I filed all of those same
All of
claims
them.
that I filed in the initial proposed amended complaint. I went ahead and filed that separately. An answer got filed, and the matter got removed to the federal district court, and the case is in suspense there pending the outcome of the appeal.
Okay. Thank you.
But my position is if your claim is based upon the fact that they make no legitimate offer, or the offer that they made in this case by way of making an offer of judgment just 3 weeks before trial, we only had all of the facts regarding my client's medical situation when I sent the letter January 18th of 2017 saying, my client's medical bills are $58,000. Her doctor indicates that the future care is going to be $200, and I send him a letter and say, why is this not a policy limits case? No response whatsoever until 13 days prior to trial, when they file a tactical offer of judgment that says we'll pay you $58,000, basically telling the client that you're a 35-year policy holder with the company, you get hit by an intoxicated, uninsured, habitual traffic offender, you've been in continuous treatment, and we're not going to offer you a dime, we're just going to tell you we'll pay the medical bills which you're contractually obligated to pay to your third-party provider. If you're basing your claim on the fact that the statute says they make an unreasonably low claim or an inappropriate claim, that a trier of fact later determines by stating that they compel you to institute litigation to recover the amounts by offering substantially less than the amounts ultimately recovered in the action brought. The jury ended up ending with interest and cost, giving my clients 20 times more than what they paid. I believe at that point is when you have the claim, because how can you ever base a claim on that issue of the trier of fact giving you substantially, ultimately recover substantially more than they've offered you if you don't know that? To file that claim before that is in essence to say, I'm speculating based upon my opinion on the value of the claim. They obviously looked at the facts and valued the claims different than I did, and I believe that's the case.
Counsel, did you argue that to the trial court?
Well, in my motions, not before the jury came back and made the verdict, that was the basis that I felt that my client now had a claim when the jury comes back.
But did you argue that, because in the briefs, it seems like your argument was you wanted to preserve your trial date and not spend $17,000, not waste $17,000 in costs. Did you also argue to the trial court, at least for this particular statutory claim, that it had just accrued and she should let you?
Well, yeah, that was the basis. That was the basis of filing the motions, because now I felt that the claim had, in essence, accrued when the jury came back and gave us 20 times what the offer was. That was the only basis we had a claim.
I understand that.
Yes.
I'm thinking about your request. It's a discretionary call to the trial court.
I understand that.
And the issue, I suppose, as a trial judge would be, you just finished this jury trial. If you have a claim that just accrued, file it as a new action.
Well, I did that, but I was trying to make sure that I was protecting my client's rights, because if it was ruled that I needed to file it in this case and I didn't want to lose my client's claim in this case, and I filed the other case to preserve the claim and also to preserve the statute of limitations. And the one thing
Counsel, if it just accrued, how can you have a problem with statute of limitations?
The argument has been, until it was just decided in within this month's Colorado Law Year, that the statute of limitations on these kind of claims were 1 year. And if this appeal was pending more than a year from now, or a year from when that happened, then my client would potentially lose the claim. If you said, well, we're not going to let you do it here, but you can go file a claim, in a separate individual claim, that would have been outside of a 1-year statute of limitations.
Well, with due respect, counsel, nothing would have stopped you from filing the new claim. It might have been dismissed later, perhaps hypothetically, but you could have walked out of that courtroom and filed, could you not, and file a new claim under the particular statutory section that we're talking about?
I in fact did that
And so
on
you did
August
that.
22nd. So I've done that.
Okay.
But when you ask me why I did that
I understand.
Now, I would like to address what I anticipate their arguments to be, that, well, they made previous claims back down the road when my client was in care and she continued to get worse and get a new diagnosis and stuff. I think to make claims that, well, we'd made these offers previously of these low amounts and some percentage of your medical bills, that's like saying, well, we committed bad faith back then, you should have sued us for that. My position is that if you're suing under this statute, you need to know what the jury's going to tell you. If the jury would have come back and sided with them, I obviously didn't have a claim.
Well, and that's fine, but almost everything except for this one statutory claim was known before trial, right?
No, because I think, just the fact that they make you some kind of a low-ball offer, that's a daily occurrence these days.
Well, and it's also a daily occurrence that you assert a bad faith claim when the injuries are substantially greater than that, and you feel that they are making that offer in bad faith. I mean, everything
I
except
don't.
the statutory grounds, the one statutory provision could have been asserted before trial, right?
I don't feel comfortable just because they have a difference of opinion as to what I do as to the value of a claim, asserting that an insurance company, just because of the negotiations that they make, are committing bad faith, just because they file some low offer. I had a case recently at JAG when they offered us $25,000. After a day of negotiation, we settled the case for $325,000. I mean, I was at trial lawyers' seminar in January 2016 or 17, and Judge Hobbs asked, how many people are getting claims where the offers are some percentage of your client's medical bills? Show of hands. Everybody put their hand up. That just seems to be standard operating procedure these days. So I don't know. I mean, some counsel believe that the insurance companies commit bad faith when they turn the lights on in the morning because that's the way they operate. I've been in practice 43 years. This is the second bad faith claim I've filed.
Counsel, the trial court can only decide based upon what you're asking and what you're arguing. You didn't say to the trial court, my claims didn't accrue yet. You said, sort of implicitly acknowledging that you had enough facts to file a bad faith claim, putting the one statutory claim aside. You said, I didn't bring it earlier, and the reason there's delay is I didn't bring it earlier because of the $17,000 in costs and because I didn't want to lose my trial date. That's what the trial court had to work with as far as because you're allowed, if there's a delay, to justify it. That was your delay. The court found that wasn't proper justification. How is that an abuse of discretion?
Your Honor, we filed it before the judgment was entered. There would have been no change in the position of the parties to allow that amendment because we would have proceeded with the new claims. And the fact that in my position, as I indicated in those motions, that the claim actually came to fruition when we had the jury's verdict. Because before that, to file the claims that I filed and to sign that pleading, I think that's just speculation. I mean, how can you go have an expert witness say, well, they offered this and I offered this, and well, what happened? Well, I don't know what's going to happen. I don't know what has happened. I don't know what the basis of this is. So that's the position that we took. My client had been in treatment almost 4 years. We'd prepared the case. We'd interviewed all the witnesses. We'd paid all the fees. She'd made her reservations. She wanted to go forward. But could I sit there and tell her, don't worry, you're going to get a whole lot of money here? The insurance company obviously didn't think so based upon the facts. But she said, I want to go forward. And we went forward. And when the jury came back, we immediately said, Judge, when you look at what the jury did here based upon the facts that were known to the insurance company, that supports this claim.
Just curious, it was removed to federal court based on diversity?
Yeah,
or-
my client lives in Texas now.
Mr. Nichols, your time that we had said was limited to 10 minutes as over and then some. So
Oh, I'm sorry.
No,
I
it's
thought
not
this
your
started
fault.
at 10 and mine says 2:12.
That's 2:12 over the 10
Oh, I'm
minutes.
sorry.
So, but
Sorry.
but I allowed you to continue because you were responding to questions from Judge Davidson. So you're not at fault at all for going over. So Thank you for your argument. Mr. Morris, you have 5 minutes to finish your time for argument in the unusual procedure we're pursuing this morning.
Good morning again, Your Honors. I will make this very, very brief. From what I heard from Mr. Nichols here, what he basically was arguing to this court here was the basis of his bad faith claim, which I don't really think is the issue in this case here. Whether or not there was bad faith on the part of Allstate's behalf is not before this court today. What's before this court today is whether or not the court abused its discretion by denying the motions to amend and the motion to bifurcate. I still have not heard anything from Mr. Nichols on how he believes the court abused that discretion. I also side with the court on in every appellate brief I have received from him, the reply and the opening brief, his basis for the abuse of discretion was the fact that he would be out $17,000 in his trial date. I didn't hear or see raised in any of his file documents anything to do with the statutory bad faith claim. And I don't believe that the preservation of a trial date and $17,000 in costs, which I will point out to the court, has not, I've never seen any support of that. It's not attached as anything. Is abuse of discretion on behalf of the judge. I think it's actually a pretty valid reason to continue on with and denying a motion to amend that's filed after a jury renders its verdict. The undue prejudice of to Allstate would have been the exact same thing. Allstate then would have had to have expended more money, much like Mr. Nichols would have, if they were allowed to amend the complaint. What's before this court today here is, like I said earlier, whether or not it was an abuse of discretion to deny both of Mr. Nichols' motions. I don't think anything has been provided by Mr. Nichols to this court that supports that the judge, by denying both of these motions post-jury verdict, amounts to any sort of abuse of discretion. If the court has no more questions, I will rest and ask that the court uphold the trial court's rulings.
Thank you very much, Mr. Morris, for your argument. Mr. Nichols, thank you again for your argument. Based on the unusual circumstances we have here, the oral arguments are concluded. The case will stand submitted, and a written opinion will issue in due course. As I mentioned at the outset of our session this morning, we will take a brief recess and adjourn and then reconstitute our division for the oral argument in Marriage of Durie. Let me ask if our counsel present for that case.
Yes, Your Honor. Yes, Your Honor.
So after counsel from this case have vacated their positions, you can set up, and we will be back in just a couple of minutes to hear the oral argument in Marriage of Durie. So the bailiff may announce a recess. As I indicated before, we have reconstituted our division. This is Division 1 of the Court of Appeals. We're pleased to be joined for this oral argument by Senior Judge Bob Kopelke. Let me just briefly review our procedures. As you know, I know we have experienced counsel, but we have 15 minutes for each side. We have the traditional color-coded timers that you may use to guide your time. We also have digital timers. If you'd like, as the appellant, for me to remind you of a particular amount of time to save for rebuttal argument, I'll be happy to do that. You may wish to focus your argument on the legal issues presented rather than the facts. As you know, we've had a chance to review the record, and so you, as I mentioned, you may wish to focus on the legal arguments for that reason. Our oral arguments are now live streamed, and so if there's any confidential or private information, you may wish to be careful as to how you refer to it. You can raise or lower the podium using the toggle switch there if you'd like. And finally, I would ask everybody to make sure that your cell phones are off so they don't interrupt us inadvertently during the oral argument. And then finally, I would note that as the parties know, we have sent out a list of questions that we'd like you to address during the oral argument. That, of course, does not preclude you from raising any other issues you would like to address during the oral argument, but we would appreciate it if you would address those questions in your presentations this morning. So with all that having been said, we're ready to go forward with the oral argument in Marriage of Durie.
Good morning, Your Honors. Craig Weinberg appearing on behalf of the appellant, Kelly Durie, who's now known as Kelly Simmerman. She was the respondent in the trial court. This case, Your Honors, like Marriage of Durie, involves an inherent tension between two policies. One is the finality, the interest of finality in divorce proceedings, and the other policy is providing teeth to the relatively new disclosure requirements under Rule 16.2. The court has set forth 5 questions, and I'd like to spend my time addressing each of those. So let's begin with question number 1. Do you agree that the holdings in Marriage of Durie, that Rule 12b-5 and Horne v. Hall do not apply to motions filed under 16.2e10? I agree that that's what the majority holds in Durie, and however, I don't agree that the analysis is correct. I'm happy if the court wants to apply that, because obviously that's what the trial court did here, but I don't think that was the right result. There were 2 reasons for Judge Furman's ruling in this regard. The first was that the husband did not cite Rule 12b-5 as authority for the motion to dismiss, nor did the parties state that standard in the trial court. Here, quite the opposite. The motion was specifically directed under 12b-5, and so was the response and the trial court's order under 12b-5. The second reason, in Judge Furman's opinion, was that 12b-5 applies to a claim for relief in any pleading, and that a motion is not a pleading, and therefore a 12b-5 can't be directed to another motion. I disagree that this distinction between a motion and a pleading should matter in this particular context and probably most others. For example, I would note that Rule 11, which addresses the attorney's obligations when signing a pleading, I don't believe anywhere in Rule 11 it references signing a motion. So are we to say that Rule 11 doesn't apply to a motion simply because it only refers to pleadings? But more to the point, I'm sure there's a lot of other rules that refer to either pleadings or motions without consciously drawing the distinction that Judge Furman drew. But most particularly is Rule 16.2, the rule that we're talking about, which is a special rule for domestic relations. Subsection D of that rule, well, I'm just going to read it because it's probably an obscure section that maybe the court's read, maybe it hasn't. But it says, within 49 days of the date a post-decree motion or motion to modify is filed, the court shall review the matter and determine whether the case will be scheduled and resolved under the provisions of subsection C, which is a scheduling requirement, or will be handled on the pleadings or otherwise. So I would ask what this specific subsection could possibly mean if there's a post-decree motion, but the trial court is given discretion to rule on the matter on the pleadings. There was no pleading that had been filed under Judge Furman's logic. There was only a motion. And then if we flip back to Rule 7, which, if we're going to draw this distinction between pleadings and motions, that talks about what a motion is and what the standard is under a motion. Rule 7b1 says that a motion shall state with particularity the grounds therefor, and shall set forth the relief or order sought. That's all it requires. The motion simply needs to state the grounds therefor. I was unable to locate any Colorado cases as to what that specific terminology means, but the federal rule is similar in language, and the cases there suggest that the particularity required in motions means reasonable specification. And cases under that analogous rule look to whether the document affords notice to the opposing party, that it provides the opposing party with a meaningful opportunity to respond, and the court with enough information to process the motion. That can be found in a case called Martinez versus Traynor, 556, Fed 2nd, 818, Seventh Circuit case. There's another case that cites to that case called Fort James Corp. Versus Solo Cup Company, 412, Fed 3rd, 1340. It was a 2005 case. So in my view, the answer to the first question is that the rules, including 12b5 and also including Rule 8e, should apply to a motion under 16.2. I'll talk more about 8e when we get there.
Mr. Weinberg, let me just ask you, is there any other motion that you can think of that is filed in civil cases in which a motion to dismiss is filed in response to it?
I'm sure there are a number of motions that a motion to dismiss could be filed, but I would think it would be fairly rare in that motions don't generally contain claims for relief like this type of 16.2 motion does. I mean, a motion usually asks for some limited type of relief within the case.
So I gather then that your view, disagreeing with the majority in Marriage of Runge, may result in the conclusion that Rule 16.2E10 is limited in the circumstances where you can file a motion to dismiss a motion under that rule. Is that correct?
That is my opinion based upon 16.2D, among other reasons. I do think that distinction between a motion and a pleading makes sense in some contexts, but not this one. And I'm perfectly fine either way, Judge. If the panel wants to follow Runge and say you can't file a motion to dismiss in response to a 16.2 motion, well, then the trial court clearly erred in granting such a motion. I'm also fine with this court deciding that on a de novo basis whether that motion should or should not have been granted, which was the subject of the briefs because we didn't have Runge at that time.
Right.
Question number 2, if you agree, what standard should apply to consideration of motions filed under Rule 16.2E10? And as I noted, I don't agree with the majority in Runge. I actually found that the majority opinion, difficult to reconcile because on the one hand it concluded that motions to dismiss for failure to state a claim don't apply to 16.2E10, but then on the other hand dismissed the motion for failure to allege sufficient allegations without a citation of what the basis for that was. And as I noted, under Rule 7, it seems to me that the proper standard is that a motion only needs to set forth the grounds with particularity, meaning it needs to give notice so the other side can respond and the court has enough information to process the motion. Or even in a more traditional sense, in the newer standard sense, if it's not a notice type issue, if we're stuck with a Horne type of analysis on plausibility. Again, I'm fine with either standard, but that's how the Seventh Circuit and the federal circuits have interpreted an analogous standard under Rule 7 as to how they evaluate motions. Question number 3, if you disagree, Why do you disagree with the majority's analysis in Runge? I think I've already covered that. Question 4, may a party filing a motion under Rule 16.2E10 make allegations on information and belief? So this sort of dovetails, oddly enough, into the first argument, the distinction between the motions and the pleadings. But first, let me point out that the information and belief allegations in this case were substantially stronger than the actual allegations that were made in the Runge case. There she had alleged things such as it was likely that husband failed to disclose and misrepresented facts. She claimed it was at least plausible, if not very likely, that husband failed to provide information, and that husband's colleagues raised significant concerns regarding husband's assets. And that's very different than the actual allegations that were set forth in this particular motion. Yes, the critical allegation in paragraph 17 was upon information and belief. Rule 8E1 specifically allows a party to make allegations. It says, when a pleader is without direct knowledge, allegations may be made upon information and belief. I also cited the court to the Gray case, which basically confirms that language. So the reason why this is important is this is a rule that's set forth under the general rules of pleading. So if we're going to draw the distinction between pleadings and motions, maybe the court might say, well, 8E1 doesn't really apply because this is a motion. And to that I would say, well, you could maybe take that limited view of what Rule 8E1 and how it applies, but if you continue reading Rule 8E1, the very next sentence of what I just read says, no technical forms of pleading or motions are required. So the very same subsection that allows pleading upon information and belief also references motions. And I think you have to construe the rule as a whole, and I also think you have to construe the rules liberally to do substantial justice under Rule 1D. Why would information and belief allegations be appropriate in a pleading but not in a motion? It just doesn't make any sense. A defrauded spouse, such as my client, is simply not going to know all of the detailed facts and allegations involved. And another reason why it would make sense to make this distinction upon information and belief between pleadings and motions is Ms. Durie, if she wanted to, could certainly file a brand new independent action, a complaint, under Rule 60B. And she could do the exact same thing that she's doing by way of motion, by way of a complaint. But she chose the methodology that the Supreme Court allowed under Rule 16.2. So again, it's nonsensical to say that while she could file an independent action and make allegations upon information and belief, she can't file a motion under 16.2 and make allegations upon information and belief. Parenthetically, I've found no law in any jurisdiction, and maybe the court's had better success than me, that addresses information and belief, the permissibility of information and belief in the context of a motion. I think it's likely because the issue is apparent on the face of the rule. And I would like to reserve the rest of my time, if I may.
Very well, Mr. Weinberg. You have 3 minutes and 48 seconds.
Thank you.
Good morning. I am Stephen Epstein. With me at council table is my partner Wendy Smock and also Mr. Stephen Durie. I would like to thank this court for the honor and privilege of appearing before you today. Thank you for sending us the questions. The answer to the first question. Do you agree the holdings in In Re the Marriage of Runge and that CRCP 12B5 and the Warner v. Hall standard is not applicable to 16.2E10 motions? And the answer is yes, I agree that that's what the opinion says. If you agree, what standard should apply to consideration of motions? Your Honor, at its core, 16.2E is an anti-fraud statute. At its core, it is designed to prohibit fraudulent disclosure or non-disclosure. As such, Your Honor, I believe that given that purpose, that this must be perceived, these 16.E210 pleadings must be perceived as claims governed not by Rule 8, but by Rule 9B. And what it states in 9B, and I understand this is outside of any analysis that's been made, but is a regression. When the Runge court said sufficient grounds have to be pled and they haven't been, I think that's an expression of the nature of the claim of fraud and the imbued sense of the judiciary that when we're dealing with fraud, we need particularity in the pleadings.
You never cited Rule 9 in your opening brief or to the trial court, right?
Sir, that is absolutely correct. Neither, contrary to Mr. Weinberg's statements, did we cite Rule 12B. Our initial motion to dismiss did not reference 12B, nor admittedly Rule 9. And Your Honors, my focus now on Rule 9 came in response to the court's order. And you made us think, well, if we're not applying the plausibility standard, we're not looking at things in a light most favorable necessarily to the movement, then what does apply? And so I kind of slowed down and I said, well, what's this all about? What's the purpose? Slight regression. Mr. Weinberg said, there's no teeth. We got to put teeth to E10. Your Honors, if you look at the entire scheme of the 16.2E, it sets forth a number of obligations, and it essentially shifts the burden of disclosure to the party in control of the assets. Where is the teeth? It's in Section J. What of 16.2? What 16.2E says is if there's a violation, and one moment, sir. Okay, 16.2E5. If a party does not timely provide the mandatory disclosures as set forth herein, we look to Section J. If you look at 16.2J, the sanction is evidentiary preclusion, evidentiary preclusion, and the other sanctions that would follow, also under 16.2 with respect to fees, et cetera. So there is teeth to it. Now, just because 16.2 shifted the burden of providing pertinent data to a party doesn't mean that it's also shifted the burden to defend an allegation of fraud to the party who initially did or did not provide. The allegation of fraud is not addressed. And the Runge court went to great length, and I need not cite it here, and the Hunt court as well, and even the initial Shelp line of cases. The judges went to great lengths to say, this is what 16.2E10 is not. And one of the things, yes, sir, I'm sorry.
Mr. Epstein, I wanted to ask you about your suggestion that Rule 9 apply, or, yes, that Rule 9B should apply.
Yes.
Rule 16.2E10 doesn't use the word fraud at all. So could you
Yes,
comment about, given that, why you think Rule 9B does apply here?
Yes, I can, sir. There's a series of cases which address this. And the case I'd like to cite to this court is State Farm Mutual Automobile Insurance Company versus Parrish. And that citation is 899 P. 2nd, 285, Colorado App, 1994. And it starts with a reference, I believe, first to a case called Groff. I'd also like to cite, it's Fidelity Finance versus Groff. And that is, cite I have is 235 P. 2nd, 994, Supreme Court of Colorado, 1951. And Groff says, fraud is never presumed, and a contract should not be adjudged voided for fraud unless the allegations and proof of fraud are clear and convincing. I believe I also have case law, and it might be in this Parrish case. And what it stands for is the notion that whether the duty applies from statute or contract, a fraud allegation still is governed under 9B. So let me, if the court will please indulge me for one moment. In State Farm versus Parrish, Judge Taubman, sitting on the panel, stated in reference to pleading fraud, in contrast, as already discussed, any claim, quote, sounding in fraud must be stated with particularity required by CRCP 9B. So whether or not 16.2 uses the word fraud, we know fraud when we see it. The allegation at its core here is that essentially a deal was in the works, that prior to execution of the separation agreement in late 14, a deal must have been in the works, or else it wouldn't have sold for so much more than wife's own appraiser came in at. Well, Your Honor, I disagree, just on that one fact. For instance, we don't live in a vacuum. We see tech companies with no profits, tech companies that are valued underwater, selling for millions and millions. And that is because there is a synergy. So there are reasons that this happens. But at any rate, Your Honor, if I might, if it smacks of fraud or sounds in fraud, then the 9B analysis is most appropriate. Now, the question is how do you plead it with particularity? The allegation is a deal is in the works. That's it. There is no particularity. And I would like to cite this is the case of Ginsburg versus Zegar, 251 P. 2nd 1080, Colorado Supreme Court, 1952. And the judges can certainly take a longer look at these cases, and I don't mean to read anything out of context, but let me tell you some of the quotes here. When a plaintiff alleges that specific material representations were made by a defendant, it is insufficient merely to characterize them as false. But such plaintiff must set forth the falsity thereof by direct and particular allegation of the true facts, demonstrating thereby that the representations are untrue.
So, Mr. Epstein, let me ask you then, anticipating your moving on to address our question about whether a party may make allegations on information and belief. Is it your view that a party may not make allegations on information and belief under this rule?
Sir, my opinion is that under 9B, information and belief pleadings are inconsistent with the requirement to plead fraud with particularity. Now, I suppose you can make an information and belief pleading that are so detailed that it amounts to a particularized allegation of fraud, but that didn't happen here. All we have here is a deal must have been in the works. And I think that is inadequate. That is not particular enough. And the particularity is also indicated, again, I think the Parrish case, State Farm versus Parrish at 899 P. 2nd 285, is very, very instructive. Let me read. To satisfy the requirement that the complaint alleging fraud be sufficient, it must specify the statement it claims were false or misleading, give particulars as to the respect in which plaintiff contends the statements were fraudulent, state when and where the statements were made, and identify those responsible for the statements. This case goes on, and it cites Wright and Miller and Moore's federal practice. This case goes on. Colorado law requires that one who alleged fraud must plead it with particularity so the allegation cannot be easily made. And that nails this on the head. The wife here had an opportunity. She knows the sale occurred. She knows who the purchaser was. I believe she had an opportunity and an obligation to do some due diligence in determining whether the allegation of fraud is made. Why didn't she go to the purchaser? Why is the wife able to come in here and upon an information and belief pleading, all of a sudden open floodgates? And the floodgates, it's not just theoretical, because we've seen it happen here. And what happens is, and in this case it's the wife, makes an allegation, nothing to back it up. It's pure speculation, just like Mrs. Runge's allegation. And then what wife wants to do here says, just because I made this up, now you have an obligation to answer discovery, and you have an obligation to defend a suit based on nothing more than speculation. And the problem with that, and it's a public policy issue, is then the husband in this case is faced with the situation. Well, I'm gonna have to pay my attorney because I had this big windfall from this company. I might have to pay her attorney. And then there's the cost of litigation and a potential risk. So I'm gonna buy it off. So what's happened here? And in this case, even though it wasn't an issue, if the court recalls in the pleadings by Ms. Zimmerman, there was reference to what we were doing in discovery. Well, what we were doing in discovery is we were using the rules of civil procedure and objecting to discovery that we believe was unduly oppressive and burdensome. But I can see a different scenario play out, and it has, where the husband is gonna have to respond to this discovery requests, which are voluminous, every single phone call made for several years, for example, and that's not fair to him. Another issue here, why, and the facts of this case suggest that the necessity to plead fraud with particularity should be the standard. Wife made an allegation. Either me or my husband, I don't know who, talked to a Mr. Clark, and we talked about synergies or mergers, okay? Well, so what does that mean? Do we have to take that as true? Wife can't say, I spoke to Mr. Clark. Wife can't say, he spoke to Mr. Clark. But wife is saying, somebody did. And we found Mr. Clark on the internet, and he's involved in this cybersecurity for religious organizations. Well, then wouldn't wife, under Rule 11, generally, and under her need to plead fraud with particularity, have some due diligence obligation? Shouldn't she have to contact this Mr. Clark and say, Mr. Clark, I believe in 2012, you either called me or my husband and talked about synergies in business. Is that true? And if it's true, let's get an affidavit. When we set such a low bar for someone invoking 16.E210, that information and belief has to be accepted as true, it is actually license for crafty attorneys to make information and belief pleadings which are going to get them through the doors of discovery without having any facts. And domestic relations is unique because there's a statute called 1410-119, and there's a case called In re the Marriage of Rose, which says the court has authority to give anybody fees at any time based on their discretion. So, discovery, the last question. I've got a minute and 20 left, minute and 10. When is discovery permitted? If the 16.E10 movement survives a motion to dismiss for failure to plead with particularity, then that party is also entitled to discovery, and the party would also ostensibly be entitled to invoke a 1410-119 motion to have the target pay for it all. Your Honor, Your Honors, I've got 33 seconds left, and all I'd have to say is I think that the court in Runge got it right. They said sufficient grounds haven't been pled. Judge Spears basically said the same thing. And in some senses, all we're talking about is nomenclature. Motion to dismiss, motion to deny. The gut feeling of the judicial officer is that this is just not enough to reopen this case, especially in light of the public policy that there should be finality to family law cases.
Mr. Epstein, I'm sorry, go ahead.
Just one clarification. It wasn't clear to me whether you agree with the opinion in Runge to the extent that it says that 12b-5 does not govern. You look instead to Rule 16.
Do I agree as an attorney, or do I agree that that's what it says?
No, well, I think you said before that's what it says.
I
My
believe
question is, should we follow that or decline to follow that decision of another division of this court?
I think that Runge makes sense. I think it should be followed. But I also think that perhaps today, we'll all be thinking about the whole line of cases, 16.8210 cases, which they're rife. They are all over the place. My office has several. We all have another one up on appeal that might be coming before you shortly. So, Mr. Capelti, I do believe that the 12B5 standard should not be applied, and rather we should be using a fraud standard. Now, again, this information belief type pleading, if it is detailed enough, it might in some circumstances reach a 9B type of qualification. However, the only allegation here is, folks, a deal was in the works, and any way you slice it, as either Judge Spears couching it in 12B5 or the Runge court saying it's just not sufficient enough grounds, it's expressing the same thing. Thank you, sirs. I appreciate your time.
Thank you, Mr. Epstein.
Let me just quickly deal with the last question on discovery. Question number 5, is a party filing a motion under 16.2E10 entitled to undertake discovery? And if so, to what extent? The answer to that is yes. Rule 16.2 gives the trial court a role in active case management on all pending issues. The motion having been filed, it was a pending issue, and the trial judge is entitled to take active case management. What does that mean in the context of dissolution of marriage? The court has guidance from the Supreme Court last year in Marriage of Durie, which is 387 Pacific 3rd 58. That was a case where the wife had brought an alter ego claim against the husband, and basically the Supreme Court said that the district court should have initially granted wife such discovery as would have been reasonably necessary to allow her to attempt to establish her claim and could tailor discovery to the needs of the case, which is what the trial court here should have done as well, or should do in the event the case is remanded. I don't think I need to remind Judge Taubman of his position in Runge on discovery. He wrote in this case, as in many others, discovery may be necessary to establish whether an initial disclosure of assets and liabilities contained material misstatements or omissions. While a trial court may be able to rule out in some cases that a motion to reallocate assets and liabilities is insufficient on its face, in my view, most cases will require that some discovery be undertaken, and that's what we were trying to do. If the court were to adopt Mr. Epstein's Rule 9b pleading standard, it places an innocent spouse in an impossible position, a person who doesn't know the details of the transaction but has enough. This isn't the suspicions that Mrs. Runge had. These are allegations that the husband was in Tennessee. Why would the husband be in Tennessee? There's no explanation for why that would be. There's nothing alleged about that other than that the buyer happens to be a Tennessee company. And that all happened 3 or 4 months before the separation agreement. And it also happened, he says, that's the only allegations, a deal was in the works. It's not the only allegation. The other allegations are that the person that was the buyer several years earlier had approached this business and tried to form a strategic partnership that didn't happen. So it's very likely, and we know that who the ultimate buyer was, that was alleged. We know these facts.
Mr. Weinberg, what is your response to Mr. Epstein's assertions that you or your client should have contacted A, Michael Clark, and B, the purchaser to obtain more information before you filed your motion?
I think that's placing it's inconsistent. Number one, he's saying it's Rule 11, Rule 11. Well, as I got done telling you before, Rule 11 refers to pleadings, that he subscribes to Judge Furman's view that a motion is not a pleading, and so a motion wouldn't require such a Rule 11 analysis if taken to its extreme. But I don't think it's our burden to do more than what we did. What's the likely response from the buyer of this business or these assets going to be? It's going to be none of your business. Issue a subpoena to us, issue some sort of legal process to get the information. Mr. Epstein has it backwards. He's putting the burden on the innocent spouse when the rules and the policies were to place the burden on the spouse that has the information. And he's yet to explain, you'll see his discovery responses in the record, everything was an objection. It's not relevant. I don't even know how it couldn't be relevant, frankly. The questions were very pointed and directed. When did this happen? Who'd you talk to? I see that, I think I'm out of time.
Yes, you
It's
are out
counting
of
up.
time.
Thank you, Judge.
Thank you very much, Mr. Weinberg. Thank you, Mr. Epstein. We very much appreciate your arguments and your coming prepared to respond to the questions that we have asked you based upon the novel and unique issues raised in this case. So we very much appreciate your having given thoughtful consideration to our questions. That concludes the oral argument in Marriage of Durie. The case will stand submitted, and a written opinion will issue in due course. That also concludes the oral arguments in Division 1 this morning, and the court will be in recess, and the bailiff may so announce.